amendments 82 and 88 in this group. Both are attempting to bring some, what I think is much needed transparency and clarity as to how and why banks are being asked to check their customers' bank accounts via EVNs. And I'm also supportive of Lord Vox's 89(7)(a), ZA. Amendment 82 requires the Secretary of State to make eligibility indicators publicly available. As you will have gathered by now, I'm opposed to eligibility verification notices in general and in principle, but if they are to remain in the legislation, we need to maximise the transparency that we have in relation to them to guard against overreach. Amendment 88 requires codes of practice to include scrutiny provisions about the algorithms used by banks, and also the effectiveness of eligibility verification measures in this clause. At present in the bill, I think that there's insufficient oversight. Now, we know that algorithms are central to this bill. This is in line with the general government commitment to turbocharge data analytics and AI into public services in general, and fraud risk detection in particular. In this bill, thousands of decisions regarding the collection and reviewing of private financial information of people receiving benefits will be, at least de facto, automated. And this is a high-risk way to facilitate making decisions, especially of a sensitive nature. Yet there's no other way for banks, building societies and so on to conduct the benefits eligibility checks that this bill compels them to do without an algorithmic system, as we've already touched on some of this. Yet the bill does not include specific eligibility search criteria of the algorithm involved, and these amendments seek to address this and because we think it creates lack of oversight. The explanatory notes do offer examples of search criteria such as capital holdings or the legal limits of stays abroad, but there's no provisions to limit the criteria or provide transparency of them. And this lack of transparency does make me question if the government are using the most appropriate mechanisms for its ends here, given the complexity of benefits eligibility per se, given individuals' varied circumstances, and given the sheer scale of the population's financial accounts, joint accounts and so on. It's just unclear, and certainly there's no evidence has been provided that I'm convinced of yet, as to why the government thinks that banks will be better placed than the DWP to conduct these complex assessments, especially when it involves outsourcing unconsented automated surveillance to third parties like banks. These are all things that we've already been discussing, so what I'm specifically looking at here is the difficulties in relation to what we're asking banks to do. Also, there's no information in the bill specifying who is responsible for supplying the algorithms required for this surveillance. So I'd like the Minister to clarify, if she would, will the DWP provide third-party organisations like banks with their existing search methodology? Who is, or will third parties be responsible for developing and deploying their own? I can understand that this might be being worked on. I've gathered from some of the things that the Noble Baroness, the Minister, has already mentioned, that these technical issues might be being resolved. But from our point of view, in terms of the face of the bill, it's not clear to me who or what will decide on the algorithms, and then there will be no accountability in relation to what we're asking those algorithms to do. Because in both cases that I've given, we need to be able to probe how the powers will be put into practice. So can the Minister tell us how much testing has been done on the systems that the banks will be using? And if it hasn't been done so far, when will we have it? I don't understand why the bill doesn't have provisions for quality assurance checks or a periodic review of these new automated systems. Without such quality checks, it seems inevitable that inaccurate information will be flagged and mistakes will occur at great human cost. And we've heard similar concerns from the Noble Lord Sicker earlier on today, and the Noble Lord Vox referenced the Netherlands child tax credit scandal, which led to, for example, more than 1,000 children being taken into foster care, and that was because of algorithmic problems, a particular use of algorithms in precisely the same ends of tackling fraud. So surely the Minister can see that the constant scanning of millions of accounts in relation to often complex queries and claims will make false positive matches for fraud highly likely. And I was trying to listen to what the noble lady, the Minister, was saying earlier about no decisions will be taken, and I think maybe we can clarify all that finally here in terms of my concerns. But there is, as a result, a significant number of, I'm worried that a significant number of false positives will lead to account holders' personal details being wrongly flagged up for further investigation to the government, which in turn may incur further privacy intrusion, let alone penalties. And I do think that there have been problematic previous schemes that we should learn the lessons from. Take, for example, Financial Institution Suspicious Activity Report, SARS, used to combat money laundering, a laudable aim. But these SARS already have problems, and a 2017 study of a sample of the largest banks found that approximately 16 million reviewed, 640,000 SARS were filed, yet only 4% of these SARS resulted in law enforcement involvement. And then there's a DWP pilot, the Housing Benefit Accuracy Award Initiative, that was used to produce a risk score for housing benefit claimants, which was then used as the basis for review of housing benefits by local councils. The algorithm flagged approximately 400,000 cases a year, identifying most of those as high-risk cases. And as a consequence, councils were required to conduct file case reviews of those flagged, which involved invasive checks of bank statements, pay slips, rent, etc. And I know someone who was a victim of this and can testify to how awful that experience was. Benefits were suspended where claimants were not compliant or able to produce evidence to support their claim. But data obtained from the DWP by Big Brother Watch, who've been absolutely heroic, I think, in alerting the public to the problems associated with this bill, Big Brother Watch found that only 1 in 3 people in housing benefit were subject to review, were in fact being paid the wrong amount. That meant that 200,000 people were placed under suspicion at the hands of an algorithm despite having done nothing wrong. So aren't the algorithm risks amplified tenfold in this bill something we should be taking much more seriously in terms of scrutiny? Recording how people's data will be assessed and not relying wholly on algorithms, we're given assurances in the explanatory notes, and the noble lady, the Minister, has been clear about this, and if I can quote, that a human will always be involved in any further inquiries and any decision taken afterwards that might affect eligibility or benefit awards. But these assurances are not an adequate safeguard alone, and we've already touched on this in earlier groups. On the one hand, there's a tendency for human deference to algorithmic outputs. We've all heard the phrase, the data does not lie, and I fear that that's what will happen. But also, courts are currently required to presume that computer systems operate correctly, placing the onus upon defendants to provide evidence that the systems they are implicated by is flawed. There is also the small matter of staffing and resources. With the many thousands of accounts being flagged to the DWP under the proposed system, it is not clear what is feasible in terms of the scale and nature of human involvement, or if it will be genuinely meaningful. The noble lady, the Minister, only moments ago assured us that there would always be members of the DWP involved. Maybe this is the kind of job creation scheme that the government are involved in, but it seems to me that that's an awful lot of civil servants that are going to be required if this fraud is happening everywhere and so on and so forth. So I worry, and indeed the impact assessment of the bill acknowledges that the DWP may have to slow the volume of data requests to manage the potential volumes, because there will be so many. If a human decision maker does not have enough time to properly review a decision, is my fear, as may well be the case with the deluge of data that the DWP will expect to receive from banks, the human input cannot be properly regarded as meaningful. Helena Wood, director of CFAS, who has had a lot of outings in this committee, it has to be said, she'll be famous by now, but she highlighted that, quote, there is a national shortage of financial investigators across the country, but if the individuals tasked with interpreting the information received from the banks are not those kind of financial investigators and do not have sufficient training, there is likely to increase the likelihood of errors. And I'm also keen, finally, to probe with the Minister how the mechanism for semi-automated decision fits in with current data protection framework. As I understand it, GDPR protections no longer apply if algorithms are seen to be assisting the human decision-making process. The NGO Justice points out that this means there's no right to be notified, let alone to complain. So finally, the lack of accountability in the bill means that there's a scope of eligibility criteria changing at any time. Surely we need transparency to understand on what basis this eligibility is determined. And as I say, there needs to be ever greater scrutiny on exactly who is setting the algorithms and what is determining what those algorithms are checking for. Oh, sorry, I beg to...